morning.
Evidence is unearthed from whatever source, because for 15 months, every stitch of evidence has been consistent with my client's innocence. However...
Good morning, everybody. Come on in.
In the meantime, my client suffers. In the meantime, her life is on hold, while she spends every waking moment defending herself, emotionally, intellectually, and financially. We cannot abide by excuses any longer. We need this court's help. We need you, Your Honor, respectfully.
Juror, quote, believes that every member of the jury, if asked, will confirm that the jury reached not guilty verdict.
Good morning. Hello, everybody. What is good? Karen Reed back in court. All I care about, I think this is on some delay here. Hold on one second. I've never had this happen before. Okay. All I care about is, let's talk about the Sallyport video. What do you guys think about the Sallyport video? That's all I want to care about or talk about. They destroyed the Sallyport video, the inverted Sallyport video. How? Over here going through like just case law after case law after case law. I color coordinate my cases, orange, blue. And I need to get one for Bev, blue ball and blowing out Bev. Case law. I just make up my own cases. I found, thanks to Annie Potts, she was like, "Lan, I need to print off these 497 pages." And I'm like, dude, Hector gets a workout in. Now I have to give pretty little Penny the printer. How many pages, how many reels of boxes of paper do you think I went through in 2024? I counted because I was doing some taxes. I do my own taxes. I write off all my strip club escapades as entertainment and interviewing process. So all my mods, they've been strippers at one point or another. So, and printer ink. So I'm going to show you what type of, you need to get the right type of, you have always do laser jet. We have these new types of, I'll show you guys. I have these just like stacked up waiting to use. But if you're going to get a printer, you have to get one that takes toner, not that like little petty ink stuff. Let's show you. Comes like this. Okay. Literally. But if these explode, you are F-U-C-K. You thought like a Bic pen back in the day was bad? I've had one of these break on me. Whoo! But this into my baby Penny over there. I have these all stacked up. But my printing paper and office supplies, I probably have one of the best accountants in Columbus. He's like, there's no way you buy this much paper. There's no way. And I said, what do you think? I just went to Staples and like sat by the door and took all of like people's receipts, throwing like paper, like products that they bought away. He starts laughing. I was like, because I always bring my bank statements in. And he's like, holy shit, you like love Staples. And then I transferred to Amazon because I'm like, I don't gotta ever leave the house. I could just get my paper and my ink, my toner. And I shit just like whoop, whoop, whoop. So in preparation for which I was expecting to be like hella printing with all these exhibits back for the Moore case, I like stocked up. And I went through, so when I do my boxes, I get 1,500 pages, like 3 reels, so 1,500 pages per order. And I was, in 2024, it was like $2,600 in office supplies for myself. So I don't know. If you divide that by 12, it's over $100, $200 a month, right? He didn't believe me. And then he saw my receipts and he's like, girl, you got this shit down. And I was like, I know. So anyways, just want to tell you guys about my printing experience. Papers just everywhere. So yeah, I've been doing a lot of overtime over here. My side job is helping moms go through divorces. So if you're going through a divorce case, let me know. I'm going to show you how to fucking loophole the system, man. You're not going to spend any money on lawyers. You're not going to spend any money on the circle jerk. So anyways, I said I'm going to start a group. I just want a Zoom of like 30 angry women blasting their ex and just clip all the parts and just have it as like a, you're not alone. We're just waiting for Bev. But while we're waiting for Bev, let's talk about what's expected here. Bev was wanting these a motion to dismiss, and if memory serves me correct, pun intended, let's see, what's his name? Or Bev said to Alan Jackson, I want this. What's the date on that, Murky? Like, Alan Jackson was like, you think that we're going to be able to have this back to you on Monday? Like, that's not happening. What she was talking about, like, last week. So, I use HP Insta Ink monthly plan. While we're waiting, you guys, I'm so happy to announce KTVB and KTVB 7 regarding the Kober hearing. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33. 33 official answers of I don't remember. I don't remember what that would be. I don't remember what the return. I don't remember. No, ma'am. I don't remember how. I don't remember. Not that my memory brings to mind. I don't remember. I'm not aware of that. No, I don't remember. I don't remember, ma'am, but you worked on the case. That's how it ends. 33s of I don't remember pertaining to search warrant. Then describing something. I don't know if he gave me a mock-up. I want a schmuck. I don't really recalls. 24. All time stamped perfectly by homegirl Truly over there. Truly's for the win. So anyways, I wanted to tell you guys about that. I was doing somebody's transcripts and I counted 76 I don't recalls in a 2-hour period when on the stand for a different case. I said, wow. I said, I think I would just say this to the to the courts. How is anything reliable when you have somebody saying, I don't recall, I'm not good with details, my memory is not good? I think that you can just say that. How is that reliable? Anyways, so now, Murky, I asked, what are we expecting here today? Because Bev obviously is not having which would be a Daubert hearing if she wanted to put Mr. Green through that. Obviously, that's not happening. I want to know when we're going to talk about the meat and potatoes of the Sallyport video. After my last live that I did with Higgins on that same day that we were in court on Thursday, I went back to some of my timelines with the Karen Reed case. And remember when Bukkake says that he met Michael Proctor at Canton Police Department? If you time up when Higgins left the Canton house to go to the Canton Police Department that morning between 9 and 9:30, guess who was all there? I have it down as Bukkake, Proctor, and Higgins. They were all there together. Remember on the stand, Bukkake said he got there around just after 9:15. And then Proctor said that he got there sometime after 10. You guys remember that? Well, I went back to double check, and Higgins, Proctor, and Bukkake would have been there all at the same time. Very, very crucial time, because the blood, the little solo cups, where were they? In the Sallyport, right? So you have Proctor, Bukkake, Higgins, and now the solo red cups in the Sallyport. And then you have Karen's SUV. Okay. Again, that SUV touched, messed with those same members with access to the solar red cups. So are we going to see emotional lemony by Alan Jackson and the team to talk about that? The fact that none of this blood evidence, none of this any testing done in the Sallyport's out. So the jury would not hear about embedded, glass, the DNA. I still scratch my head unless you're really going to come hey, on the shards that were broken in the lawn, there's no blood on those. But why don't we just get rid of it all and don't even let the jury hear it? That's a strategy. I think the last trial they said, oh my God, everyone's going to see that this was all planted. Well, we saw that the jury is not like that. So what do you guys think? Thoughts on that? Are we going to resurface this puffy winter jacket? Video Jesus was on last night on Young Jerks and said the Sallyport video was clearly manipulated and went through the steps and believes Colleen did it. I think Colleen's a piece of shit. How about Turtle Boy's shirt the other night? Julian Nagel's a piece of shit. I said, damn it, Turtle Boy. Coming with the 1-2 punch. Julian Nagel's a piece of shit, period. What do you think? Yeah, probably. I saw a black blob. Can we get that as a shirt? Did you guys see that shirt?
We are not afraid.
Julian Nagel's a piece of shit. Like, that's all it says. Julie Nagel's a piece of shit. In bright orange. Like, fucking love it. How do you not laugh at that shit? No, I laugh. Where's my phone? He had to turn his shirt inside out. Why? What happened? Why? What happened? Why would he have to turn his shirt inside out? Here you go, Bella. I was just praising your work.
Oh, did you see it?
Your work of this. Here you go. Kevin Reed case is presiding over by the lovely Bev Blowout Banger. Just the banging twins over here. Good. Yeah, I saw them. Thank you. Just the banger twins. All right, let's go. He was on a roll the other night. The Sullivan sluts, he was calling them. I just was, I was LOLing. LOL smiley face. Let's go look at this. Come on, Bev. Yeah, you give that one over there. It's fine. Yes. What? Live coverage. Karen Reed. Oh, Karen Reed trial watches. Who should we watch through today?
Always long time.
Always.
Court TV's audio is horrible.
Court TV sucks. The court made him because he had his mugshot on his shirt. Oh, you're not talking about the Julie Nichols shirt. You're talking about a different time, Heather. Okay, interesting. The court made him because he had his mugshot on his own shirt. And that's just witness intimidating. We have sources that have said that Bev has been going to Starbucks in the mornings and has become a regular at a couple of the Starbucks in town. One specifically where I personally asked for a favor if anybody out there that are working the Starbucks, when you know how you can write on someone's little cup, if you can put, please, just one time, write Bev's bingo with Bev, something to do with Bev and bingo. Take a picture of it and send it to me, because that's what I want on my shirt. I want a Bev's Starbucks cup, but I want it to be where you put her name as bingo Bev, Bev's bingo, something with Bev and bingo. Please, if you can make this happen, I would, and it has to be like authentic. I want the receipt that shows that it's like a Massachusetts Starbucks, So if you could just get this on over to me, that'd be great. I know, Yuri. Exactly. Jim. I was also looking into more about Lally and the fact that Brennan is doing it and Lally's not. And Brennan's basically saying that the Commonwealth was ineffective. More or less, like, how is Lally and Hank Brennan working together? Because I'd be like, fuck you, dude. Saying that, like, we were ineffective or blah, blah, blah. I wouldn't be cool with that, So curious your guys' thoughts on the relationship between Lally and Hank Brennan. How do you guys think that they're holding up? God, throat. All right, we're going to go. Oh, here we go. I think we're live. I think Bev's in. Here we go. Full screen.
No, because I've been waiting for it. And
recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do and why.
Okay, I want to make sure we didn't miss anything.
Here, the motion, I'm not going to exclude the.
Okay.
Morning, Mr. Lally.
You're on there, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. My name will make sure your cell phones are off and put away.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lowell for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so to start, I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So after review of the pleadings, it's clear to me that the issues that give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to be resolved by the jury. So I'm denying your motion. I'm not going to exclude the evidence. All right, so then I think what I'd like to move to is the defendant's motion to recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson,
I want that.
what it is you're asking me to do and why.
Does anybody have that response from the state?
The court did receive
I mean, come on.
addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it. And I checked as recently as 5 o'clock yesterday and this morning.
I'll get it.
Okay.
So that's
Do you have an extra copy? for
What?
me? Because I don't want.
It was coming from, the final copy was coming from Ms. Little from back in my office. That was,
When did she send it?
when? Yesterday, I think I was on the plane.
Margaret checked for me yesterday.
I think it was yesterday. I think it was really due. I remember.
Can you come here for 1 second, please?
What an asshat.
Who is she? Did she send it to all the clerks like she's supposed to, or just Mr. McDermott?
I think she sent it to everybody. Her normal file.
Oh, I'm sorry. Yeah, I'll check it. Yeah, no, Judge reminds me, I did get something else.
It was from the Commonwealth, so I've been waiting for this, so I need a
That
minute
was
to
sent
read
at
it.
12:57 p.m. yesterday.
I did not get it.
No.
How did he not get that?
More importantly, the Commonwealth got it, right?
Yes, that's my copy I handed to Counsel.
Oh, thank you.
These lying bastards. So the Commonwealth got it at 12:57 yesterday. I forgot we can fast forward a little bit because we were waiting for Bev to get blown out, but all right. Alan Jackson's gonna oral argue this. Dude, Alan Jackson's been doing some serious flying. Bev's reading. Look at that courtroom. I wonder if Boston 25 News has this banner up so that nobody can see Turtle Boy's laptop when he said this is Ken Mello last time he's been in a courtroom. That was, love it. My type of humor.
Wasn't there.
Okay.
Okay, so let's see.
That this information was erased or that it wasn't there.
Oh, wait.
To save me time, does your
God, we're waiting for Bev.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what
All right.
our concerns are in my oral statement.
All right. I'll hear you.
May I?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8, subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame, to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sallyport, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sallyport video just a few days ago, this one showing the Lexus backing into the Sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that, the reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me, Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech expert. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know, maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that, and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason. Zero. The 30-day override protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her
Fool's
making.
errand. Fool's errand.
The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official database, which is supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher.
Dumpster fire?
The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much.
Let's hear it. Woo! He used the word liar, dumpster fire. I can't. I love it. I love it, AJ. Now here's Hank Brennan for the Commonwealth.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, MVR back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Any quick response, Mr.
Very,
Jackson?
very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins' part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. to my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean. Let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one totally, I wasn't the one that downloaded it. I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out. No hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround. And it was ultimately at her cost. And that's what's.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought, what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed? And did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
So-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as an
as an
exhibit.
attachment, but it was
but
never
not-
any,
Right. There was, and I don't mean to cut off the
no,
court,
no.
Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, I need to see
By
that.
the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr.
to,
Jackson.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamped. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the
We
committee
wouldn't need to
case,
be here if they did it the right way.
self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that. And they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, sorry, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right, Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
searched.
commonly is overridden every
Yes.
30 days,
That
like
has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when
Who
somebody just
retired?
copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know.
Why
you
wouldn't
said
they do
you-
that today?
they could, download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, they want to have somebody there.
Just do it now. You guys are all there. I don't
All right,
understand
so I'm
that.
telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you.
Wait.
Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion for sanctions or to dismiss, or whatever the remedy is, because they think they've been aggrieved, that would be a different motion. This motion is they're trying to get the court or asking the court to impose costs because they had their expert come out at their request. And they were very clear about the risks associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right.
Wouldn't they need it? It has nothing to do with your ruling.
All right, so let's move on to the Commonwealth's motion for clarification regarding the search warrant. Or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attaches addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government of the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st trial, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, it was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search
Right.
warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. On January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, he can get the raw. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right. It's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes. So the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
Federal court, okay. All right, so they're at a sidebar. Federal court. Well, Brian Higgins committed perjury. I mean, he lied. Everything is a ripple effect with this case. That's what I don't understand. Like everything, it's a cause and effect. If things were done the right way, I mean, so somebody downloaded within the 30 days the entire file allegedly and put it in an iCloud account. Then during the trial, then use that file rather to distort and manipulate to invert the video, which then they used at trial, and then broke off pieces, but then somehow, how did the Brian Higgins clip where did that come from? Because that was clearly importantly kept out, because otherwise Karen would have gotten she would have gotten Higgins's phone. That clip alone would get Karen, Brian, Albert, and Higgins's phone back in the day when I think when it was downloaded, it would have been the original. Then if there would have been manipulations off of that, then there would be like another download. So I think what you can do is go based off of the day that the downloads were downloaded to know if they would have been manipulated or whatever be in the iCloud account. So I would do it off the date. Because I bet you they didn't try messing with that stuff, within the same time period of the 30 days to then You guys get what I'm trying to say? So for example, today, I have to mute this. I'm not listening to this. God bless America. Oh, God. So if today there was a murder and I download from an iCloud or from a DVR to an iCloud account, the video, I would then have to, within the 30 days, make a distorted or manipulated version so that I could try to claim that it was actually when I downloaded it. But then, as we know, that would out them anyways, because it would have been the inverted Sally port and everything would have to be. So I believe that this would be an actual video. Like, you're going to be able to prove it so easily. I just wanted to walk that through. I try to give you my head to your head. I don't believe that the work would have been able to be done because they've already admitted that it has been inverted. I think it's fascinating that we just found out that there's an iCloud account that has this entire 23 hours and 59 minutes. And I'm so unclear as to why Hank and Alan Jackson just don't go over to wherever this, come on down to the office, or here, we have a laptop right here. Let's just do this right now. I don't understand what they think that they need to do. It's almost like one of those things like, do they even need to do that though? A detective sergeant downloaded it. I always said, why didn't you call Ken Berkowitz to the stand in the first trial? I was unclear about why they never did that. I was unclear why they never called Kevin Albert. Even if it wasn't just to get some. Did Ken Berkowitz have to talk at the federal grand jury ever? And that's why they didn't have to, because they had that. If he was sick, they would have allowed like a deposition or a recording. Like, they would have just done a bunch of different things. I'm talking about. Wild. Yeah. God, I can't handle that noise. What? What? I'm talking about the beep, beep. I'm like, geez.
That's what I'm saying.
I also think that what's his name just said it. Hank said that this guy routinely does it. That means that everybody would have known that Sergeant Detective routinely downloaded stuff to an iCloud account. So if you work with the Canton Police Department, you would have known that, Lally. And hey, did you download that? Can I get that? You get what I'm saying? Like, Hank just used very interesting language when he said that this Sergeant Detective who's retired, and I'm not so convinced that it's him. Is there anybody else that retired as a Sergeant Detective? Because maybe it is him, but you can mute the audio while they are at Cyberlana. Yeah. That's what I'm doing. Do you guys hear it? I muted it. See? Mute, unmute. Does everybody understand what I'm getting at? Is that there was no way that the Commonwealth didn't know about this. I believe that the Commonwealth would have received this from whoever the iCloud account belonged to. Let's see. Lady Di, that email that you sent me has nothing to do with Hank's affidavit that has the officer's name in it. I know that you sent me that. That has nothing to do. That's with the Cellbrite extraction. That's not what we're talking about. I'm looking for Hank Brennan's affidavit. So let you know where Hank Brennan's affidavit is. That's what I'm looking for. So the whole point is that whoever this iCloud account belonged to and did all that, that is what they used as because there would have been no more DVR because it had been deleted after 30 days. So the copy of it, the only thing that would exist is the iCloud account one. And whoever the owner of that, it had to be the person that was breaking off the Commonwealth with the little clips or with it in its entirety. And then somebody went ahead and made X, Y, and Z when they inverted the video, when they altered the video, overlaid stuff, when they deleted 46 minutes, 42 minutes. Right there, though, during this oral arguing, I don't know if it was Hank or I don't remember if it was Alan Jackson, talked about that the car was being reversed into the Sally port. That there was a video that now just surfaced about Karen Reed's car reversing into the Sally port. You guys, we've never seen her vehicle being drove in and when they said like backed into the Sally port. When did we ever see Karen Reed's vehicle being backed into the Sally port? Let's see. Okay. Now, Lady Di. Now she gave me Commonwealth's opposition to defendant's Karen Reed's motion. Let's print this. And in it, does it say the name? Or does he take that out of the... Okay. Woohoo, Lady Di. This is what I wanted. Now we just need Hank Brennan's affidavit. But I bet you that's totally sealed, wouldn't you think? Maybe not. Now comes the Commonwealth. The above caption matter opposes the defendant's motion. Okay, boom, boom. The Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of this case. At no time has the defendant ever made a formal preservation request. Now, I don't believe that that's true. In November 2024, the defense made an informal discovery request relative to additional Canton PD Department videos. Special Assistant District Attorney Brennan responded on, okay, informing the defense that he would inquire the Canton PD or the keeper of the records. During the week of December 1st, ADA Brennan spoke by phone with Attorney Jackson and his co-counsel, Alan Jackson, okay, allowing the defense expert to access. C, defendant motion at P. Okay, 2P. Okay. During the phone call, Alan Jackson expressed concern that the video footage would no longer be stored, and ADA Brennan acknowledged and shared Attorney Jackson's concern given the passage of time. Attorney Jackson requested that the Commonwealth refrain from accessing the system prior to the defense expert's examination. ADA Brennan met with Canton Police Chief Rafferty and received permission for the defense to search for video from the Canton Police Department's DVR system relative to the storage of the defendant's vehicle. Pursuant to Alan Jackson's request, ADA Brennan directed Chief Rafferty to advise her staff not to disturb the NVR. Did he mean to say DVR? Moreover, in efforts to identify video footage and chain of custody, ADA Brennan visited the Canton Police Department, viewed camera locations, and had a discussion with retired Sergeant. It's not the guy that we thought. Thank you. D. Gambitro. Petru. D. Gampetro. Yeah. D. Yeah, G. Petro. Hell yeah. He's not dead. This is amazing. Wow.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Good job. Good job, Lady Di. Woohoo, baby.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses in trial.
And you've asked for, you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson.
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses, We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just?
Here.
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
Wow.
How about the Commonwealth?
There are none expected.
Wouldn't you be looking to toss the car? Like, I don't understand how you're not saying that none of this is admissible. We have no idea what these people did with the vehicle. They must be planning a bunch of stuff with this motion to dismiss. I would have loved to know the thought process on not suppressing this.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss.
He wanted March, February 20th.
And we'll hear it if there are no evidentiary. Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay.
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take 2-8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
It's due today. It was due the 6th. So today's 6th.
Can I hand this in, Your Honor?
Thank you.
Thank you, sir.
All right.
What a shit show. Another shit show, Bev. Good job.
So all reciprocal discovery be provided by March 6th. All right. Thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
All right. Boo. Yeah, okay. So February 5th, Commonwealth will file certificate of compliance. February 6th, motion hearing. So they did all that today. Then, so Bev moved. So motion, February 11th was supposed to be filing of motion to dismiss and all non-evidentiary motions. But that has now switched. So the defense will be filing on February 21st, 2025. February 14th was Commonwealth to file opposition to motion to dismiss, but that's not happening until now, February 28th. And hearing on motion to dismiss was February 18th, 2025. Obviously, that's not happening, but she's keeping that date. She has said that we're going to do the motion to dismiss is going to be on March 4th. Which is going to take the place of hearing of all evidentiary motions, such as like, I would love to know the reason why you wouldn't be suppressing stuff in this case. Your guys' thoughts. Don't forget to leave your DNA, absolutely. Spicy Chicken Nugget says, this has been a shit show for 3 years. I will be having bingo cards available for the hearing for motion to dismiss on, because she has dates set for 4th and 5th. So March 4th and 5th, we'll be playing bingo over here, and it's going to be spicy. It's going to be obviously any lawyer or Bev and what they say. So you have to show how shady they are to prove the frame job. Yes, but we also talked about the fact that full-throated. There you go. The jurors, it's going to be interesting to hear from them.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
Court, on line, please.
Okay. So main takeaways. So main takeaway number 1 is that Bev's bingo is back in play for the motion to dismiss to hear that. It's an evidentiary motion, hearing all evidentiary matters. Again, that's March 4th. She has it listed down March 4th and 5th. We'll see what ends up coming with that, but we're planning on Bev needs time to read it. Then on March 7th, there's a final pretrial hearing and filing of all motions in limine. Maybe we'll see something there. My big takeaway is, do we think this is going to go to trial? What do you think is on the whole entire video? If somebody downloaded it before it could be manipulated, that means it's going to show I'm still going with my gut. I believe that vehicle was in there, okay, or a vehicle was in there because there was snow, and then a vehicle gets taken out. Then Karen Reed's gets drove in, but I was like, wait, maybe they're just doing this part to like. Why would ever a tow truck driver ever drive in a vehicle? They never would if there's cops there ever. So then I said, okay, this is all manufactured. And damn. Would you think that the broken light would be on there then? Them popping the light there? Do we think that the light was popped there? I do agree Karen's SUV was in there before they started the recording. Yes. Yes. And then it was removed. And that's why I almost think that they didn't pop it in there. I also think, did they pop the wrong side? You guys, did they pop the wrong side? Because in order to make a full break so that somebody could put it all back together, is there a chance that they popped the wrong side and then just kept out a couple different pieces? And I think that there's a chance that they popped the wrong side. So I think the Brian Higgins part's just fucking awesome. I think that all of those people that testified knew or had reason to believe, I should say. Do you feel like Bukaki was surprised when he was shown the inverted video on the stand? I mean, think about how fucking dumb that is. You're going to sit here and think that you're going to get it past the defense that was not inverted. I just, and the whole world's watching to then even just be able to tip it off. No, he knew. No, he was surprised when they found out. Do you think that he knew that it was inverted? I'm saying, do you think that he was surprised that what version did the defense ever get? It not inverted? Was the defense ever provided the inverted video? If you're going to introduce something in court, you have to provide the other side with, so like here you go. That's your copy. This is my copy, right? Plug her in. And then I show this guy these, okay. For example, I'll show you what I mean. Okay. Back in the day when all those people were trying to fuck with me, they tried to provide evidence on a thumb drive. And what they did is they screen record one of my live broadcasts. But when you screen record something and it's not live, obviously you do it at a later time. There's ways to determine that where it says, when you're screen recording, it says video was posted 20 hours ago. Video you know, there's ways to see, oh, it says like live replay, you know, that kind of gives it away. But I argued that this thumb drive, for example, if it was of a video that was recorded 20 hours after I made a video, I know the date of the actual video. So let's just go with February 1st. 20 hours later would go into February 2nd, right? But the date that's actually on the thumb drive that says when it was put on this could be a different date. And let's say that almost a year had gone by and it's in December of like the following year or whatever. Why wouldn't you argue that where's the downloaded version of the screen recording that you did 20 hours ago? Why is this of something that's almost 9 months later? Like, clearly you screen recorded it. And then so it would have been saved to a device when you screen recorded it at that exact time, 20 hours later. But then here, you turn over to me 9 months later from the day of the screen recording, this version. How does this prove that you actually were the person that screen recorded it? It doesn't, because the screen recording shows that it was done 20 hours after the original air date. This shows that it was produced 9 months later, but it was produced in a download. So how do I know that the person that actually screen recorded it is still the person that downloaded it 9 months later? And like, would this be faulty? Because I think that's kind of what they're saying here is the iCloud account, and they word it differently. They say, prior to its motion for costs, ADA Brennan informed defense counsel during a conference call that retired Sergeant, we'll call him D, would routinely save video copied from the NVR onto the department's hard drive. ADA Brennan offered to produce a copy of the storage footage from the Canton Police Department's hard drive, or alternatively allow the defense direct access to the hard drive. The defense deferred this offer and has requested further information about the hard drive storage that is forthcoming. All of this is property of the police department. This is going to get tossed. Like the whole entire case. This is a Brady violation. Like this is a Brady violation. This is not going to trial, and I wanted it to go to trial. Because what Brennan's basically disclosing here is that they have had for the whole entire time, since clearly within 30 days that this would have been downloaded of the incident occurring, right? Oh my God. That it wasn't turned over. It's property of the Canton Police Department. And this person, this whole time, this retired Sergeant D, okay, he would have been watching this trial, knew about this trial, at the very least would have been like, wait a second, I'm the one that downloaded that. I'm the one that did this. Alan Jackson's figuring out how to play this. What's do you have to get permission in Massachusetts to depose somebody from the court? Can you do depositions? Because it's in Hank Brennan's because I kind of agree with Hank Brennan on something. I don't know what's on. Okay. I don't know what's on the DV. I don't know what's on something. So before you would go and fly in like an expert and do all of this, is there a way to check to make sure? I don't want you to incur all these costs, right? So you say this to Alan Jackson, right? And it's 2025, 2024. We have all this technology. Why aren't we on like FaceTimes and just like doing something? This just doesn't make sense. But I think I'm starting to figure out why. I love watching Lana think through stuff. Do you? Because this is just a really interesting the way this is worded. Think about this. Prior to its motion for costs, think about this. Prior to its motions for costs, so before they ever motioned that they were going to go after the money, ADA Brennan informed defense counsel during a conference call that retired Sergeant D. Gampitro, whatever, how he ever says his name, is in Italian, disgracing my, would routinely save video copied from the NVR. How did he get information about that? So why did Hank Brennan talk to this retired sergeant? Why did he ever think to go talk to him? So would routinely save video copied from the NVR onto the department's hard drive. So the department's hard drive was there the entire time. Anybody and everybody would have access to it to be able to look at it, because I'd be like, he said the word routinely. So there'd be nothing new to go and look. So anybody at that point could have said, hey, that dude always is downloading the stuff and put it on the hard drive. Go get a copy of that, which then anybody could have went and made like this. All right. Like, this is not the first case that this department has ever had. So they know where to go. And ADA Brennan offered to produce a copy of the stored footage from the Canton Police Department's hard drive, or alternatively allow the defense direct access to the hard drive. Yannetti's in town. He's the local lawyer. So is Leshy. I mean, I guess I don't understand. I do, but I'm not going to tell you why. There's a reason that they didn't just go forward with that. And I believe it's just Alan Jackson's standpoint is that if that exists, because we already know what's on it. If they inverted the video, that means it wasn't inverted at one point in time, right? And if it was a direct download of whatever's there in that time frame and it was never altered, and that's the actual like here, this could be modifications. If you're taking it from my hard drive, it hasn't been modified until you get a copy, a working copy, and then you start fucking with the working copy, and then that's what you're producing. And so all the snippets are coming from a downloaded version that I made into a working copy, and then I made multiple copies off of that. So well, here, if you're going and getting something directly from a hard drive, and then they mentioned this iCloud account, which I think that's coming out in his affidavit, which if we have now. Exactly. Lally never told the defense, which is a Brady violation, and it's all gone. So that's why I think that Alan Jackson's saying is it doesn't matter it does not matter. He's at step 15, and Bev wants Alan Jackson to walk her through steps 1 to 15. Whereas the judge from the Alec Baldwin case didn't need to be walked through 15 steps to know that this is a freaking Brady violation, you know? Lana, please look at Missy Wood's CBI lab analysis. I think she has ties to this case. Sure will. It's a huge Brady violation if that happened. Well, it did happen. That's what I'm saying. And I think that's why Brennan is not wrong in some of his arguments. I don't think he's wrong in some of his arguments. I think he's like, okay, you're mixing the two here because I didn't my conversations with you were about this and I disclosed X, Y, and Z. Okay. You wanted to set it up that you had, you know, this expert and blah, blah, blah. We didn't know what was going to be on it. So I didn't send you on a wild goose chase. All right. Now, and my response is it wouldn't have mattered what was on it. It matters that it was there and not turned over to the defense. And we already know what would be on it because of what was produced in the first trial that was inverted, right? So that means there was a version not inverted. And that version, along with the inverted video, shows manipulating of evidence. I mean, this is criminal. But at the end of the day, it should never even came down to a jury deciding. It should have been tossed. So I think there's strategy involved with what Unetti and Jackson are doing, because I'm over here screaming, why aren't you going with Alan? Why isn't Alan Jackson, Karen Reed's team, right now, Hank, let's go get this hard drive, okay? We want to view together what's on it, going step by step. We have a Richard Green on FaceTime right there watching us do it, recording it, all right? And then you have somebody just recording this whole process, and this would be, don't you think if Hank Brennan sees a video in the presence with the defendant's lawyers, don't have Karen there, and they're all watching and it's being recorded of people destroying evidence, what's Hank Brennan going to do? I think Bev is saying that she wants this motion to dismiss because she's going to dismiss this case. I do. I know that sounds crazy. Lana, but it's Bev. It's Bev. It's Bev. You guys, this has gotten to another level. Okay? This has gotten to a ridiculously other level, to the point of, like, it's one thing for me to look away, but I'm not going to be part of it. And as a judge, you're believing your prosecutor. Okay, you're believing your prosecutor. You're believing your prosecutor. Alan Jackson is dealing with a beast that he's never dealt with before. That normally, because lawyers don't deal with this type of shit, you don't deal with people that are flat, blatantly doing the type of shit that's going on. This is unprecedented. Okay, there's still clearly a bunch of federal shit going on. But I think Alan Jackson might have been stalling a little bit to push this back, to see, like, come on, you guys have to, like, pull the trigger, waiting in terms of, like, the feds. But Alan Jackson, they're playing, like, chess with these people, because what would be so simple is to go down there and to see, like, clearly you had it. This guy is your witness. I downloaded it. everybody knows that I downloaded it. I know that people would get copies from my downloaded version because that's the only thing that could have produced this shit. And I think that's what everybody has to focus on is the timeline of the download was clearly made within the 30 days. That would have been, you're not manipulating something from the original version. I'm telling you, let's put it to you this way. If you did that, there'd be evidence on your shit. You would never want to do that. You just would assume to delete it after you've made one of these and then claim a malfunction happened. But, oh, thank God we got one of these though in time. I just want to know how much money Karen Reed's going to make. She's going to be one rich lady. Let's see. I think this is super interesting, though. I know that what's his name filed a preservation. Then she's acting like it wasn't part of our record. What is she talking about, man? Let's see. Affidavit. Yeah, this is what I want. All right, here's Hank's affidavit. Did he spell his name wrong? That's funny. Okay, my name is Hank Brennan. I have been appointed special blah, blah, blah. I began my appointment in mid-September of 2024. I learned that the Commonwealth sought and obtained a search warrant. Okay. I learned that the phone information. That's what this is about. Oh, it was filing 26. Yannetti did it. September 16th, 2022 at the very latest. Defense emergency motion for preservation of evidence allowed February 2nd. What a bunch. Bev Canone. Her name's on it. 10/3/2022. Oh, shit. Bev. Okay. Question, Lana. You think the Fed investigation clearly still ongoing? Oh, fuck yeah. 100%. Absolutely. That video proves that Higgins on the phone, that video proves that he lied to the feds. And so the feds are either going to use that to say, you want to wheel and deal yet? Or otherwise, we're charging you with perjury. So I think that Higgins is going to now have no choice but to either wheel and deal with the feds, or he's going to go and take he committed perjury. So here, did I print the other one? Let's use Hector. I got more papers over here that I don't even know what to do with. I think this is so interesting, though. Because if I just had just give me the discovery and I'll put it all in a timeline for you very, very well. Like I'll just dial it up. Somebody who's doing like a timeline for them, like everything, every day that something happens, pop it in there. I just don't understand. All right. Okay. Affidavit of Special Prosecutor Hank Brennan in support of Commonwealth's response to defendant Karen Reed's motion to recover. Okay. So this is his work. Let me zoom in. Yeah, me too. It's the Me Too movement. Okay, so I learned the Commonwealth sought and obtained a search warrant for the defendants. Okay, what does that have to do with what you're saying, though? I learned that the phone information was provided to the Attorney General. Okay, pursuant to the privilege. Yep. So then they had to. All right. I learned the Attorney General's office provided reports relative to communications, navigation information, and Google searches. I recently learned that the Attorney General's office did not provide the Commonwealth with the related raw forensic data. After consulting with forensic experts, I believe comprehensive forensic review of raw data within the scope of the search warrant will provide more information than the reports. Okay. I think he's just doing his due diligence. I mean, maybe Hank's going to move for a motion to dismiss. Maybe they're going to come in filing for a joint motion. I don't know. I learned that the defendant's been in possession of the entirety of the data, including the raw data from her cell phone since 2022. Although I do not believe my requests involve communications and thus not subject to the communications protocol, I requested the Attorney General's office engage in a filtration protocol for the files I requested, including navigation information and Google information. This request was an effort. Yeah, he said that. I informed the defense of my efforts, and the defense advised of its objection. I do not believe the defense has any standing to object. However, after receiving the defense's objection, I contacted the Attorney General's office and asked them to limit the production to files identified by the Commonwealth's forensic examiners. They just want the navigation. Based on my conversations with a forensic expert and understanding of what a privileged attorney-client communication consists of, I do not expect any communications to be stored in the navigation files. Upon speaking to the Attorney General's office, it is my understanding that they would like to follow the filtration protocol previously set forth by the court, blah, blah, blah. The Commonwealth is seeking clarification so that it... Awesome. Great job, Hank. This is all that matters. Right there. How is this not in by itself? So what's the rules in Massachusetts? Can you depose people? Nobody can be deposed there? Prior to its motion for costs, ADA Brennan informed defense counsel during a conference call that retired Sergeant D would routinely save video copied from the NVR onto the department's hard drive. Everybody knew this there. Everybody that worked in Canton knew this there. ADA Brennan offered to produce a copy. So right there, this is where they got a file like this from this downloaded version from the hard drive. But why is Alan Jackson talking about an iCloud account? There is no language in here about an iCloud account. This is the Commonwealth's opposition to defendant Karen Reed's motion to recover expert-related expenses from the Commonwealth. So now comes the Commonwealth, blah, blah, blah. The defendant's suggestion that the Commonwealth misled or induced the defendant to incur costs to have an out-of-state expert travel to the Canton Police Department is a distortion of the facts and has no legal merit. The Commonwealth requests the court deny this motion without a hearing. Well, they had a hearing. The Commonwealth has provided the defendant with numerous videos from the Canton Police Department throughout the entirety of the case. How come? Why would you need to provide? Why wouldn't it be like this? 12 to 11:59. Like your 24 hours. Here you go. They may be in clips of like every 30 seconds because the file would be too long to just like continuously run it. So you have however many clips of 30-minute videos, all right? But guess what? Like, it would all just be right here, right? Why are you, if they did exactly what he says he did and he downloaded it, then the only other option is that when people were asking for clips, because the defense never asked for clips, they said that, and that's a big point, is we've never just said, hey, we want the time frame from this time to this time. They said they want the whole day. So provide us the whole day. Let's see. Deb's a moron. What affidavit of Hank's was that? That was an affidavit for fuck no. Who knows? Doesn't even make sense. I'll tell you that the way that they have to produce stuff, like to break it down, you do. If you're going to do 30-minute clips, I understand that. But we're going to make sure that they're always, like, there's no seconds missing. This is the, it was stamped September 16th of 2022, but defendants, defendant's motion to renew motions previously filed in Stoughton District Court prior to indictment. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to reaffirm and allow the defendant's motions that were previously filed and allowed in Stoughton District Court prior to the indictment in connection with this matter. Specifically, the defendant respectfully moves this honorable court to reaffirm and allow the following motions. So the defendant's emergency motion for preservation of evidence, and it was allowed February 2nd, 2022. Defendant's motion for inspection and independent data retrieval. Defendant's motion for preservation of tower dump evidence. Defendant's motion for complete file of crime laboratory allowed to the extent that such materials are within the custody/control of the prosecutor. Defendant's motion preservation of Google geofence data. Defendant's motion for preservation of vehicle event data recorder evidence. Defendant's motion for leave to file further discovery motions. Defendant's motion for notice of exhaustive forensic testing. Defendant's motion for production of documentary evidence. And then good old Bev. Was this denied? What does that say? Received? It's her name. 10/3/2022. That says received, right? What is this? What's this? Does that say denied? Or is that an R? Received. Defendant's emergency motion for preservation of evidence. I saw a different one because he's saying physical evidence. There's another one that's out there then. Defendant's motion to renew motions previously filed in Stoughton District Court prior to indictment. We're over here renewing these just to make sure that everything that happened over there, we're bringing over here. This has to say received. Yeah, that cannot denied. Received. It looks like to me it says received. I'm going with received 4,000. Let me print. I'm going to pull up Hank Brennan's affidavit that we need here. That's from the other one. He's just filing affidavits over here like it's fucking one of. Everything has to be up. Lally, you waste of human space. Like, hold on. Let me get the. He filed 2 affidavits, you guys. 2. So we need. Oh, fuck. I think that says 100%. It says received. There's no, definitely denied. Definitely received. Yeah. RECIEV. How about this? This is why you don't do what Bev is doing. Oh, here is his affidavit. God, Hank, what the fuck are you doing, Hank? This is just a pure shit show. The Commonwealth never suggested that nearly 3 years later, on December 12, 2024, that video footage from January 29, 2020 would still be stored on the NVR system. Nor did the Commonwealth in any way hinder the defense's desire to have. But what is? I have a question. Please ask Lally if he read this when Hank was like going to be filing this. Because wouldn't Lally be like, there is nothing on that? Like, wouldn't Lally know? Isn't Lally an extension of the Commonwealth? So if he knew something, he has to tell that, right? I just think that this paragraph right here puts Lally on the hook because he knew it. He knew it. Anyways, absolutely ridiculous. Get his fucking ass up there. Let him smoke on the stand. Who gives a shit? Give him a couple cigarettes. It's all good. Lally is a witness. My name is Hank. I have been appointed special prosecutor as lead counsel. I began my appointment in okay. During my initial review of discovery and documents in the custody of the Commonwealth. In the custody. Very important language there. But now in Idaho, the custody. What are the police? Are they they're an extension of the prosecutor, but the custody. So that's interesting. Of the Commonwealth, I learned of a letter written by Canton Police Department Chief Rafferty dated August 21st, 2024, accompanied by a zip drive that contained video footage of multiple areas of the Canton Police Department. During my initial review, and if this was dated this time, remember he says that he came in September of 2024. So this was dated this date. review. So it was in the file. So between August the 21st and Hank coming on, wow. Accompanied by a zip drive that contained video footage of multiple areas of the Canton Police Department. Accordingly, I promptly provided these materials to the defense soon after becoming aware of the information. Well, I guess my question is why did Hank think that the defense didn't already have it? Let me repeat this again. During my initial review of discovery and documents in the custody of the Commonwealth. So you're looking at discovery. That's all the discovery form. Like the notice of discoveries, they had one Roman numeral to, so many of them. So you're looking through that, okay? So you're looking through this and the documents in the custody of the Commonwealth. I learned of a letter, so that was put in discovery. That would be in his possession. I learned of a letter. Oh, wait, hold on, though. Could it be sneaky here? I learned of a letter. That's another way of saying that's hearsay. During my initial review of discovery and documents in the custody of the Commonwealth, which means it's not in discovery, in the custody and not in discovery of files that would be labeled notice of discovery. Okay. I learned of a letter written by Canton Police Department Chief Rafferty dated August 21st, 2024, accompanied by a zip drive. Zip drive. Okay. Accordingly, I promptly provided these materials to the defense. Why would you think that they didn't have them? He's going to say because of this date. Well, how do you know that Lally didn't turn over before you got involved here? So there has to be a chain of talking about it. It would be Brennan to Lally to show him, and then Lally saying yes or no. And then Brennan, then Hank going to the defense. That's how that would have had to happen. I promptly provided these materials to the defense soon after becoming aware of the information. There you go. Notice of discovery 47. I had phone calls with Attorney Jackson during the first week of December. Attorney Jackson requested an opportunity to have a defense expert access the Canton Police Department NVR for examination. Holy shit. Okay. All right, guys, let's be smart about this. Jackson wasn't thinking that it would have anything on there. He wanted it for something else. I agreed to seek permission to allow the defense to access the NVR for examination. I contacted Canton Police Chief Rafferty and obtained permission for Attorney Jackson's request. I informed Attorney Jackson that I would have an MSP officer attend along with NCDAO forensic examiner present. I also informed Attorney Jackson that we would videotape the procedure. There's videotape evidence of all of this. Attorney Jackson expressed concern that the materials may no longer exist on the NVR, given the time that had passed since the event. I agreed with him and told him that I have no knowledge whether the materials, I have no knowledge. This is all about Hank. I am not at fault here. And he's saying, I have no knowledge. Well, once you inquired, I have no knowledge whether the materials still existed or were overwritten given the passage of time. And what Alan Jackson is saying is right there. It says that they delete every 30 days. I never represented that any video from the storage of the defendant's vehicle would exist on the NVR system nearly 3 years after the event. Attorney Jackson requested that I refrain from having anyone access the NVR prior to his expert's examination. I agreed and informed Chief Rafferty of his request that no person access the NVR prior to the defense examination. I personally met with Chief Rafferty and requested that no person access the NVR prior to the defense expert examination, and Chief Rafferty agreed. Putting the blame then on Chief Rafferty. That last part's really important for Hank. What was in the motion to recoup the recovery of all this money? I have to look at that again. Hank Brennan knows that there's a huge Brady issue, okay? He was trying to keep the two separate, though. But I thought the whole point, God. Okay, guys. Alan Jackson is saying, where did this inverted video come from? Okay. You provided it during the middle of the trial. Where did it come from? And so Alan Jackson is showing that it couldn't have come because he's doing his motion to dismiss. So he has to do these fucking steps. Holy shit, I know what he did. Okay. Alan Jackson did all that for intel. For fucking intel. Because this proves that the Commonwealth committed a Brady violation. Because the whole time they knew that it was saved. And they never produced that. They already, during the 30 days when the incident happened, they saved it. Okay? They saved the original. Then they made a working copy of the original saved. So then you have this. Then they did all the shit that they did with this. Okay? Because remember, now we're getting to the fact that when Hank Brennan turned over stuff that he had seen, right? This is what this is the one that was originally downloaded, wouldn't have had any changes. Okay. Then they made a working copy, because that's what you do. You make a working copy so that detectives can then have this. This one stays in evidence. You have this one, you plug it in you're working from it, and then you're making like your reports to say, like, if you're doing timestamps, this is your working copy. This is not a copy to then manipulate the evidence. Okay, so then here you have your working copy. Hold on, let me show you really how they did this. So you have, this is your original. Working copy, which is a copy of original. And then then they made the defense's copy. But this came from the working copy, and it was only clips, which we'll use this one. So this is your original. Then they made a working copy of the original. Then they gave the defense clips of the working copy. Okay. And then in trial, they made another copy from and they inverted it. The working copy, they made a complete copy, and then they inverted it, which they never gave to the defense, the inverted one, okay? And so what I was assuming that this was all about is I thought that they wanted access to, it's like, we want what you presented. I thought what this whole thing was about is I want what you presented in the courtroom during trial, because I want your inverted video. Okay. Hold on. Let me back out. Because what I'm going to show is that the inverted video isn't the same as the one that you gave us. Okay. But in order for you to invert a video, you would have had to have the original, and you used timestamps that we didn't even have. So it doesn't come from this, because you're approving stuff in the terms of during the course of the trial. If I have one, you have to have the mirror copy of it. So these two matched, okay? These two matched. Had to have. Because this is what the Commonwealth had, and this is what the defense had. Then the Commonwealth introduces this one. And we know that this one couldn't have come from this, right? And it had to have come from somewhere else, which is that there is an actual copy, right? And so what the defense created was we're going to prove all of this. And this is how we have to do it. So I'll say it one more time. So here you have the DVR. there'd be a date of this supposed iCloud / download. So there'd be a date, but here's your original DVR. Then they made a working copy. Or I should say they made a copy of the original right here, and it was a hard drive. So then they made a working copy of original. And this is the Commonwealth because they got it from the police. Then they mirrored that so that here's the defense, and they have the same thing. But when they did this would have been their working copy had clips, okay? Had clips with the 42 missing. All right, so I'm going to explain this. DVR system, the MVR, the guy that did it, this detective sergeant, he made a complete copy of all 24 hours before the time had elapsed. Okay, so within 30 days. Then from this hard drive, somebody took this, inserted, and only drug over clips and left stuff out. So this is why that 42 minutes was missing. All right. And so they only drug certain clips. And then this is then considered the working copy that the Commonwealth had. And they made an exact replica of these clips to give to the defense. So this is what's happening at trial. Then during trial, inverted video clips. And obviously didn't come from the defenses. Okay. It came from, because the defense didn't have this. And so these clips were made after somebody made a copy of this and then made another copy to produce this. So there would be another thumb drive in between that. And as Alan Jackson said, we asked people, where did this come from? Where did this come from? And everyone's pointing the finger at everybody else. That's what he says here today, as we saw. So Hank Brennan then comes into the picture. And Hank Brennan, between September and December, gives the defense Rafferty's zip. Okay. It was a letter. And turns that over to the defense. which is a different one. Okay. This has Brian Higgins clips. And then now here's where it gets good. You take this whole thing and you look back at the picture and you say, wait a second, where? So if you back out and you look at this as a whole, okay, wait, this has stuff that this doesn't have, that we didn't have. Where did the stuff that this has come from? And that's how they were able to figure this out, that they knew, when I say they knew, Alan Jackson knew that somebody made, and that there existed an exact copy of the 24 hours that were being requested. He knew that the system wouldn't have that. Okay. It wouldn't still be there. All right. But what it would show is that, Your Honor, in order to have this, that Helena Rafferty had, okay, it doesn't have what was on the inverted video. It doesn't have the working copy that mirrors what was given to the defense, okay? And that means that the working copy that the defense in original discovery gave us, they knew that that wasn't the complete copy, and that they've always had in their possession this puppy because it produced what was given to us by Hank Brennan after he reviewed the files in September and read the letter. But the question is, and this is the $1 million part, which is awesome, why Lally's fucked, is that Hank Brennan would have no reason to think, yes, Helena Rafferty writes a letter. So whatever the letter says in August of 2024 matters, because where did she find this at? She was just snooping through, you know what I mean? To say that she gave it to, clearly the Commonwealth, because it was in the file prior to Hank Brennan ever coming on in September. Okay, because it was August. He comes in on September. And so Hank Brennan would have no choice but to say, okay, I see this is dated August 21st, 2024. Clearly the defense wouldn't have had this, during the trial. But have you looked at it to see if it matches the copy? What's new on it? Is there anything even new on it? You'd have to have communication. And that puts Lally directly, unless Hank is taking him out of it, saying, I didn't talk to Lally. But that means that Hank would have had to review like the original one to see that, wow, this isn't the same thing, because maybe it's just the same thing as this. And it was like, hey, I just turned this over because I came across it, whatever. But ultimately, Rafferty turned something over to, and that was in the discovery files. Does that mean that it was requested for at some point by Lally? But this is what proves that this copy didn't have it, that you guys introduced at trial, which is like, again, where did this even come from? We have the matching ones that we both were using at trial. And if this has stuff that's not on here and not on here, then it had to come from somewhere else, which means there's still a huge ass file out there. And lo and behold, here we are today when now this detective DiGeronimo comes up and forward because Hank supposedly just had a conversation with him, which I believe Hank had a conversation with DiGeronimo because of what was written in the letter from Rafferty to say that DiGeronimo always saves stuff, blah, blah, blah. That's where he got that information from, is my guess is the letter. And now all of a sudden there's a hard drive that has 100% material that was always there, because I believe that this would have been the original one that should have been produced to the defense, but they couldn't do that because of the shit that was on there. Somebody said, no, make a different copies, clips, give them here. The 42 seconds is missing, and then went ahead and felt the need to, at some point, which you have to ask yourself, what was the point of the inverted video? Which would have been known by Lally when he has this. He knows that this isn't this copy, all right, that he's always had. So here has a copy that has never been turned over to the defense, but more importantly is an inverted video of. So explain to me how this isn't 100% criminal as fuck. This is manipulating, fabricating of evidence. And you have to ask, for the purpose of what? And so people want to say, like, Hank Brennan isn't, like, if Hank Brennan doesn't give this new one that he got in August over to Alan Jackson, right? Then Alan Jackson wouldn't know that, boom, exactly. This one right here, and I have a feeling that the date, because I'm going to revert back to what I said in the beginning when I said, hey, guys, somebody screen recorded me. And the date of production, though, that when I plugged in, they gave me a copy, let's say at trial, and I got a copy of it, the date of it, I was like, holy shit, look at the date that this was made. I have a feeling that the date of when this was made was in February of 2022. You understand what I'm saying? It's the date of whatever was on the zip drive to see when it was created originally. And I believe that the date of when it was originally created with these clips that were then just recently turned over, the date is February 2022. And now, ladies and gentlemen, that's how you win a case. That's how you win your dismissal, is to show these dates. And that's what's going to show that this existed then, okay? And now Rafferty, when all she's going to testify to is that, yeah, it existed because there was, now this is where DiGeronimo comes into play. Yeah, because I downloaded the whole thing when it happened and I put it on the what do you call it? I put it on the hard drive. Oh, what hard drive? And then when you see that the Commonwealth / the police department, this hard drive that then produced the working copies, which aren't the replicas of this, they're only pieces, then you know that from the beginning, it's a Brady violation. They had the exculpatory evidence the whole time. And not only do they have exculpatory evidence, but they have inculpating evidence. They have exculpating and inculpating, because it exculpates Karen Reed, but it also inculpates people. And inculpates people in the frame. And now this is why you wouldn't move for reasons to exclude evidence. You need to show all of this. Because I said, why aren't we moving to this? Well, because Alan Jackson is going for the fucking throat here with this motion to dismiss. This motion to dismiss is going to show exactly what I just showed here to a T. Sorry that it's like kid style, but it's accurate. And this is going to inculpate every single person. And now I know why he doesn't want to go and touch this yet. He's asking around to see what information can we obtain from that. Can we see based on if this file, like each time that it was opened up, how many times it was, like, what can we learn from this before we just go all willy-nilly and go and meet up with Hank Brennan and start looking at shit. Okay. So he set up the whole, because this whole motion came about, it was that they destroyed the evidence from the trial, which was the inverted video. That's how this all came about. And which is this. It's like, wait a second, we preserved shit. Where is the inverted video that y'all use? We want this. That's what it was destroyed. Like, and now Alan Jackson had to make, I don't know if he moved to keep it out. But he said, no, guys, listen, I used to be an ex-prosecutor, right? I have so much experience, right? What they have just done here, leave it alone. And we're going to circle all back to this when, if the time is necessary. And he would have to say to Karen Reed, you're going to have to trust me on this. Okay? Because we know what they did. We have to prove it, though. We have to prove it. So we need to set traps along the way. And every trap was just laid down to literally a T to be able to say, boom, this exists the whole time, which was the replica, the original replica. And then all of these working copies were made and used for the purpose. Remember, we can't forget about this middleman one. I think I have another one I can put in there because there had to be a middleman working one to then produce that one. So let's see if I have another one here. Yep, sure do. So that's the middleman working one to produce then the inverted video. And I think the reason that Bev is a little bit out of the loop on some of this is because Alan Jackson wasn't playing his hand at sidebar. That's my take. But what do you guys think? And then the feds, you're going to take to the feds a huge RICO case. This is a RICO case. This includes, do you understand Brian Higgins and who he was on the phone with? We can eliminate the fact that Brian Higgins wasn't, I don't think, on his personal phone. I think he was on his work phone, right? Did Brian Higgins have both a work phone and a personal phone? But whoever Brian Higgins was actually on the phone with, all right, at 1:35 is, I think, going to be, it's going to bring it all down. To say that at first I thought, oh, it's got to be Brian. It's got to be Brian Albert because he's calling to say, hey, no, nobody's called in. Nobody's called. She hasn't called looking for him. She's like getting all eyes on Canton, right? With going to the police station, finding out what we need to find out, right? Get a Faraday bag, whatever, right? But if you got two guys that are at the house, the Canton house together, being Brian Higgins and Brian Albert, you would be saying things like, don't call my phone. You know, like they know what to do. So therefore you're now putting in play possibly a burner phone. Okay. And you're possibly then putting in a burner phone of Brian Albert but more importantly, were they even thinking that far ahead? But that phone call, whoever he was talking to at 1:35 a.m., it's who would you call? Who would you call if you had and you needed help to clean something up? You were just with the dude that you left the house with. Why would you go be on the phone calling him when you can just drive back over and say, yeah, we're all good? Now let's go back to what Alan Jackson was asking Higgins on the stand. He was asking him if he called, because it was like this, Ken Berkowitz, right? But Ken Berkowitz called you. So when you woke up in the morning, why didn't you call Ken Berkowitz back? Why did you call Brian Albert, or did Brian Albert call you? But Ken Berkowitz called you, right? And he called you at what time? And so what makes sense to me is that Ken Berkowitz called you because you possibly called him at 1:35 a.m. All roads would lead to the way that Alan Jackson was questioning Shipwreck on the phone, on the stand. Was he the only person he wanted to keep involving in everything was Ken Berkowitz. Ken Berkowitz and Kevin Albert. Were you relaying information? Were you doing this? Were you doing that? I love it when Alan Jackson said, so you just went over there to play parking lot with the cars? Remember when he said that when you're going over there, you decided to go play parking lot? Anyways, so this all was laid out. And so people want to give Hank a hard time. I'm telling you guys, if Hank's doing his due diligence, right, and then they come across like Hank's like, let's look at this. What seems to me that Hank's doing here is he's going off a checklist to say, oh, I did this. I can't move forward with prosecuting Karen Reed. I try to dismiss their witness. I can't dismiss the witness. He's doing everything to say that he exhausted all efforts to, that's what it looks like to me. Higgins said at Berkowitz's retirement party that CB is the guy you call if you need to hide a body. Berkowitz died a month ago. No cause of death listed. The butt dials were at 222, 223. I always said, let them get your phone records. Who cares? Who cares? Let them get your phone records. Who cares? I don't believe that what's his name ever went home that night. And that's why I think that people should look at those videos way, way closely to see what people are wearing. Did Higgins have a jacket on? Was Higgins no longer with a jacket on because it was on, what's his name? It was on John O'Keefe. So in the video, when he's on the phone, does he have a jacket on? If he doesn't have a jacket on, I think that that's fucking going to be unbelievable. So we need to know if Higgins had a jacket on in that video at 1:35. He's on the phone, and if he is without a jacket, I don't think Higgins ever went home. Remember, because they had to do a bunch of shit still. They still had to lay out his body. All right, guys. Anything else? Anything else? So, but this would be the original. And it is there, which means what would be on that is how they, and in this show, this proves the date of this zip drive would prove. That's what I think is like the alarming part of it. All these people are involved. You remember Alan Jackson asked, hey, did they ever ask to look at your car? Did they ever ask to search your inside of your car, look at your car? Go back and listen to what Alan Jackson was doing multiple things. That's why I was like asking myself, why the fuck is this cross-examination so lengthy that you're losing the jury, right? I was very highly critical of it last Thursday, and it ate at me. I'm like, there is no way that Alan Jackson wouldn't know this. Everything that he did in cross-examining Higgins was for something else. You understand? So now when you lay all this out and then you talk about the feds, he was walking Brian Higgins, here's the rope and you're going to hang yourself. And he was getting him into testifying on numerous topics, because I was like, what the fuck's going on? For this case, you're showing the jury, like the jury is not following any of this shit. It wouldn't make sense to them. Yes, they did. And not only did they get a new piece in January, but that's the piece that has the Higgins on it. Or is that the piece that came in from the September, Hank reading the letter and giving it to him sometime between October and December 1st? AJ's playing because he knows that he's like, when Bev is ruling a certain way, he's like, fuck, we have to go about this completely different because Bev's not going to give it to us. So we have to get it a different way. No, they got the Higgins on October 8th. Okay. So then January. Yeah, they have the January clip is Karen Reed's vehicle being backed into the Sally Port. So earlier I had said, you guys, that we've never seen a clip ever of Karen Reed's vehicle backing in. We've only ever seen her vehicle pulling in, right? So backing in would be a totally different time, which is the time period that I believe happened, which is they had to more or less, for the camera's purposes, I think, reenact that whole pulling in. Like, was it doctored up so bad that they have the vehicle driving in on the tow truck? Like, is it that well clipped that it's pieces from a bunch of different things? And the backing in now to the key starts, right? They backed it in and then realized the right rear tail light would face the camera. I believe that they didn't I believe that the car sat there, you guys. The SUV sat there for at least a lengthy period of time where snow fell off of it and it created the box outline. Remember back in trial 1, I said, you guys, look at this. That vehicle was in there before because there's snow perfectly lined up when it pulls in that we see. What the hell? This was in there before that. I agree. So they pulled it in. Whether they backed it in, pulled it in, whichever one they did first, it had to have sat for, now think about the 42 minutes that's missing. And it was just in that outline. And I was like, but whatever obviously happened in the 42 minutes is crucial. It's not missing because nothing to see here. Do you think that it's all crazy then? That, oh shit. So think about this then. I got to get another one out. If nobody ever knew that this Detective D did that, then that means these motherfuckers, because they would know it would always be there. That means that they weren't even working off of this one because they didn't know that it existed. If by chance, then that means that there would be 2, because how did this one not even get destroyed before then? So they're putting into play then. So if this is the Geronimo guy, or however he says his name, you actually have, this could have been the, we'll call it the Ken Berkowitz one. Somebody. Because my question would be is, why would they not have ever deleted it from the hard drive? Oh my God. Holy shit. Okay, I want you guys to hear me out. Oh my God. Okay. So in the Brian Drake case, how we receive stuff, if I'm using the actual hard drive to then here, I need to plug this in and I'm going to drag over 30-minute clips with this purple one. Okay. You can do it. You can piecemeal it. Oh my God. Wow. These people are so fucked. They're all going down. They're all going down. You guys, the greatest thing about all of this is that all of these have dates. That's how I was able to catch it with these fucking idiots that did stupid shit. I saw a date on there. I was like, oh my God, what the fuck? I was like, that's not the same date. I said, that's like 9 months later. There's all dates associated with all this shit. And this date is going to prove that that existed in February of 2022. Wow. Remember how Alan Jackson's been talking about these little clips, how they're getting these little piecemeals, these little clips? Damn. Because somebody has to physically sit there if you want to break it up properly, and you have to drag files, and you have to wait. Like when I say you drag files, you're making. At that time in 2022, they would have had Google Link. There's a Google Link out there. Hey, when you do in Canton, if you want to get a request for FOIA request, how do they send the body cams when you do a FOIA request in Canton? We have to do a sample one, and then I'll be able to report more on something else. Because they do links. And do you remember when Alan Jackson was asking, how was it turned over? Was it in a CD? Was it in a this? Was it in a link? Oh, fuck. Okay, I gotta go. We don't have body cams? What are you talking about? Dash cams, whatever. Let's go with dash cams. You guys have dash cams there. The dash cams. Was it in a link? Yeah, but this totally inculpates and during the civil trial of Karen Reed being able to civilly sue all these people, she's going to even get more leeway to get way more shit because that's just what happens in civil cases. Wow. This is crazy. I think if I was Paul, I'd be walking my civil suit back. All right, guys, on that note, much love. See you on the next one. Peace out. So you can go play parking lot. You just thought you'd go play parking lot at 1:30 in the morning? He doesn't even answer it. Only reason I don't want it to get dismissed, guys, is I want trial 2.0. I want these motherfuckers to go down, like in front of our eyes. And everybody that's saying out there that Karen Reed is so guilty, and dude, I have no idea what you're watching. Can you just set that aside about the whole Karen Reed being guilty? Because we can't even get to Karen Reed being guilty or anybody being guilty because of this fuckstick job right here. And this is all police work. Corruption. Take it out. Thanks, guys. Thank you, mods. Appreciate you guys. Till next time.